Hello, my name is Manisha Haldar and my roll number is 1801100. Today I will be talking about the importance of timely justice in courts on Indian economy. In the Economic Survey 2018, one of the most unnoticed yet important factor impacting the Indian economy was put under light. That is the effect of pendency of cases in judicial arena. Enforcing contract is a very important parameter for overall calculation of ease of doing business report. Though India jumped 30 places to enter into top 100 rank in the ease of doing business report 2018, but India still lags behind in the parameter of enforcing contract, merely improving 8 ranks to come at a position of 164 in 2018. Timely justice in the courts is very important because delays and backlogs of cases results in hampering enforcement of contracts and resolution of disputes, thus leading to stagnations of the projects and then escalating the cost of the projects and disrupting the tax collection process and demotivating investors to invest. Thus, it is very important to escalate the timely resolving process of the legal disputes to boost the economic activity. As per the Economic Survey 2017-18, approximately 1.8 lakh cases are pending in 6 prominent appellate tribunals, that is the shipping, power, road, petroleum, mines and railways, that deals with high-stake commercial matters, and there is approximately 25% increase in the number of unresolved cases. The average age of pendency in these tribunals is 3.8 years. Economic Survey studied 3 types of cases: company cases, arbitration cases and taxation cases. Though the number of economic cases is less than that of other case categories, but the average duration of pendency is the worst in most of the cases, that is nearly 4.3 years for 5 major high courts, with average 6 years per case for tax cases. Economic and commercial cases tend to take more time than other cases due to their complexity and thus require economic expertise in handling them, thus taking more time to resolve these cases. But the expansion of discretionary jurisdictions by court is also attributed for overloading of the cases. So now we will see some of the reasons for the pendency and the delays. The monetary losses due to pendency of the cases is humongous. The government project cost of state cost due to court injunctions in 6 infrastructure ministries amounts to approximately Rs 52,000 crores. The project under the Ministry of Power, Roads, Railways are worst affected, with the project cost increasing by 60% since the project costs were predominantly debt financed. The rising pendency of cases at the appellate tribunals, high courts and the Supreme Court, with more usage of injunctions and other blunt instruments, has impacted the corporate India, thus increasing its legal expenses. Pendency areas and delays can also be witnessed in the tax departments and their multi-layered process. According to Economic Survey, as of March 2017, there were approximately 1,37,176 direct tax cases under consideration at the level of IT-80, High Courts and Supreme Court, and mere 0.2% of these cases constituted nearly 56% of the total demand value and 66% of pending cases, each less than Rs 10 lakh in claim amount, added up to 1.8% of the total logged up value of pending cases. The context is quite similar in cases under indirect tax, where a total of 1.45 lakh appeals were pending with the Commissioner Appeals, High Courts and the Supreme Courts. Together that value to Rs 2.62 lakh crores. So how to combat this problem? The total expenditure on administration of justice by states and the centers amount to approximately 0.08 to 0.09% of GDP, which is quite less when compared to other common law countries. Research shows that though the general spending on the judiciary may impact pendency, Subtly, but the expenditure done on the modernization, computerization and introducing technology results in shorter average trial lengths. Data compiled for the economic survey reveals that nearly 30% of shorter average trial lengths cases life is consumed in formal proceedings like service of summons and notices, issues that may be easily resolved through technological upgradation for filing and serving mechanisms. The government can appreciate the efforts and the progress made in alleviating pendency in the lower judiciary by providing performance-based incentives for the states. Further expenditure may be prioritized for filing, service and other delivery-related issues that tend to cause the maximum delays. Though the experience from the 1990s showcased reduction in pendency cases after increasing judicial capacity in the case of income tax appellate tribunals, but increasing judicial capacity may not be effective unless existing capacity is fully utilized. Because we can witness that the higher judiciary is currently operating at 63.6% of existing capacity, instead focusing in building capacity in the lower judiciary to particularly deal with the economic and the commercial cases will help the high courts to focus on streamlining and clarifying questions of laws. This would require amendments to the Code of Civil Procedure, Commercial Courts Acts and the other related commercial legislations and training of judges, particularly in commercial and economic cases, by judicial academics. Early results from the Delhi High Court has indicated that downsizing original site jurisdictions in 2016 helped the court with more time to reduce its overall pendency, thus downsizing original and commercial jurisdictions of the High Court and enabling the lower judiciary to deal with such cases can be considered. Creating more subject matter as state-specific benches will help the court to build internal specializations and efficiencies in reducing pendency and delay. As cited in Economic Survey 2018, Ease of Doing Business 2018 spotted specific issues in India's poor court management and court automation systems. Hence, it is important to focus on courts' case management and court automation system. We can even look forward towards initiatives taken by UK in introducing Crown Court Management Service that are responsible for the management and handling of the administrative duties, thus freeing up the judicial time. As we can see that the cooperative federalism in terms of vertical cooperation between center and the state in GST implementation helped in bringing transformational economic policy changes, similarly, we can expect the same horizontal cooperation between the judiciary and the executive or the legislature to bring up significant reforms to promote speedier justice and thus helping in the overall economic activity of our country. Thank you.